lady. I represent the appellants with Dr. Barron, and the respondents are represented by Dr. Ashland and Dr. Stewart. On this appeal, we contend that the learned judge made an error of law by failing to follow the principle identified by this court in Bozzoli and Phillips and Aces Tech. That principle is that in addressing a submission that the subject matter of a patent is obvious, the court should not take into account perceived problems which are not plausibly solved by the patent. And we submit that the learned judge, in his analysis of inventive step, erred in attaching weight to the following deficiencies in the prior art, which are not addressed by the patent in suit. And these are as follows: that pending human clinical trials, there was an uncertainty around beta-3 agonist therapy as an approach for treating OAB, that it was uncertain whether mirabegron, the claimed compound, was in fact a human beta-3 selective agonist at all, or alternatively was not a potent one. And the third, which is an amalgamation, probably the first two, is that it was uncertain that mirabegron will be efficacious in treating OAB in the clinic, in people. And we say that insofar as these uncertainties exist, the patent does nothing to address them, and therefore they should not have been taken into account, and the judge erred in taking them into account. Our case, that the patent is obvious before the judge and today, is a simple one. We say mirabegron was disclosed in the prior art. That is to say, its structure was disclosed, as was its method of synthesis. And it was disclosed as a human selective beta-3 agonist. And those matters are odd. We also say it was, and as a matter of common general knowledge, known that beta-3 agonists have potential for use in the therapy of OAB. We say, therefore, no invention can reside in claiming that mirabegron is suitable for such use, particularly in the absence of any further technical teaching, material technical teaching. Now, in giving permission to appeal, the learned judge acknowledged that a point of law arose as to the interaction of Connor and Aces Tech, which obviously we will be looking at. He recognised that a different interpretation of the law could lead to a different assessment of obviousness in this case. We've reproduced that acknowledgement. This was on permission to appeal. We've reproduced that acknowledgement, paragraph 4 of our skeleton, and it's also can be found at paragraph 32 of the judgment on permission to appeal, which is at tab 12 of the full bundle. I was proposing to structure my submissions as follows. I was first proposing to draw your attention to aspects of the common general knowledge by reference to the judgment. I was then going to turn to the patent and the prior art. I will then look at the law before turning to the judgment itself. So, my lords and my ladies, starting with the technical background and the common general knowledge. Overactive bladder is a condition which is relatively common in older people. It involves hyperactivity of the bladder muscle, which is called the detrusor muscle, which gives rise to an urge to urinate even when the bladder is not full, and it may or may not be associated with urinary incontinence. If I could invite you to pick it up at paragraph 53 of the judgment. We can see the just the key elements there. So there's a picture of the bladder in paragraph 53, and you have the urine enters the bladder from the kidneys, the marked ureters, the sort of little ears sticking up at the top. And then one can see the bladder wall. That's an involuntary muscle. It's called the detrusor muscle, and makes up the body of the bladder and can contract or relax. And then there's the intrauteral striated sphincter. So that's the voluntary muscle that we used to prevent ourselves urinating consciously or release when we wish to urinate. And there's autonomic nervous regulation of the bladder, which, crudely put, increases or decreases bladder contractions. That's contractions of the detrusor muscle. And as the judge records at paragraph 57, that's the last sentence, put simply, it's the sympathetic nervous system that is active during the storage phase, so that's when the bladder is relaxed, and it's the parasympathetic nervous system which is active during the voiding phase, that's when it's contracting. So in other words, the sympathetic nerves reduce detrusor activity. And if I could invite you just to have a look at paragraph 68. And again, you see the same elements of the bladder. And we've also got on the left and on the right the parasympathetic and the sympathetic innervation. And when a nerve enters or attaches to a muscle, it's not wired like a 13 amp plug. It acts through through these synapses. Looking for the word there, and you can see the sympathetic one, which we're particularly interested in, on the top right, and the bladder muscle is at the bottom, and it has what's called an adrenoceptor. And when the impulse passes down the neuron, it results in the release of noradrenaline, and then the noradrenaline passes over a small gap and attaches to the adrenoceptor, and that sets in motion physiological activity, which in the case of the sympathetic nervous system is relaxation, and in case of the parasympathetic nervous system, it's a different substance, it's an acetylcholine muscarinic receptor, and that leads to contraction. The sympathetic nervous system is regulating all sorts of activities in the body, not just contraction of the bladder or relaxation of the bladder. It's regulating heart rate, blood pressure, gastric motility, the airways, and there are different types of adrenoceptor associated with different tissues. There are two broad classifications of adrenoceptors: alpha, which we're not concerned with, and then beta, and the beta are subdivided into beta 1, beta 2, and beta 3. And the pharmacologist understands that a pharmacological effect can be created by using drugs to block a particular adrenoceptor or by activating an adrenoceptor. And my lords and my lady will be familiar, I'm sure, with the term beta blocker, which are used for lowering blood pressure. They act on beta 1 adrenoceptors, and those inhalers that we puff when we have an asthma attack, they're short-acting beta 2 agonists. So if you want to create a particular pharmacological effect, you need an agonist which is specific to the receptor of interest. And here we're not blocking, we're activating, so we want an agonist, and we're interested in beta 3, targeting beta 3. There is some similarity between beta 1, beta 2 and beta 3 because of their evolutionary history, and they're cousins, so to speak. So some drugs may be agonists for beta 1, beta 2 and beta 3, whereas others may be selective, and that is just affect, say, beta 3 or beta 2. And that is what the term selectivity means, and we'll be seeing that quite a lot. So it's selective for the particular type of adrenoceptor. So a human selective beta 3 agonist is a compound which activates beta 3 but does not activate beta 1 and beta 2. And as we shall see, that beta 3 selectivity was considered desirable. Activation of beta 1 can cause an increase in heart rate, tachycardia, and agonist activity of beta 2 can cause muscular tremors and so forth. So the aim is to target beta 3. The other thing to keep in mind is that there are differences. This is important to keep in mind. There are differences across species So a beta-3 agonist which is effective in the rat may or may not be a beta-3 agonist in humans. And if it is a beta-3 agonist in humans, it may not be as potent as it is in the rat, and it may not be as selective as it is in the rat, and vice versa. And then finally, one needs to keep in mind that the tissue distribution varies between species. So, for example, in the rat, beta-2 and beta-3 are both associated with bladder relaxation. So, with that, sorry, rather brief and cantered introduction, if I can go back to the judgment. And the learned judge is describing methods of investigating new therapies, and these appear in the patent in suit, which is why it's worth paying little attention, and indeed in the CGK. And the first one is an organ bath methodology, and essentially you just cut strips of bladder muscle, you put it in a bath and under tension, and then you watch its tendency to contract both with and without your drug of interest. And sometimes it's just a piece of bladder tissue, sometimes it's stimulated with either potassium chloride or a substance called carbachol. Conceptually pretty simple, and of course you can do this with either a rat bladder or a human bladder, and human bladder tissue can be obtained from people who have to have their bladder removed as a result of cancer surgery. Then there are in vivo methods, and again these were performed in rats, all part of the common general knowledge. The details are not important and are rather gruesome, but the first one that the judge mentions is artificially filling a bladder and then watching its tendency to contract with and without the particular drug of interest. And then at 78 he refers to some pathological models, and there's one where you can partially tie off the bladder for a few weeks and result in a hypertrophied, unhealthy bladder that's prone to frequent contracting, and then you can apply or not apply your drug. And then at 79 he refers to a further one using compounds put into the abdominal cavity, cyclophosphamide and so forth. And the judge at paragraph 81 says the experimental techniques described, examples 1, 2 and 3 of the patent, were part of the common general knowledge. And my lord and my lady, the details, I'm not spending time on this because I don't think the details are important, as long as one understands in broad terms what these sorts of tests do. Then if we move on to 86, and the judge is setting out certain matters that were known about adrenoreceptors. Just looking at Roman 2, one needs to be a little bit careful. He says, the learned judge says a number of beta-3 adrenoreceptor agonists were thought to be selective were known. He's not at this point dealing with human selective, he's just dealing with rat selective, with the exception of 507, which we'll come on to, but just he makes this clear later in the judgment. I'm just alerting you to that. And then at 87, he's making the point I made in the introduction that the rat and the human beta-3 adrenoreceptors differ materially in their pharmacology, such that agonists which were selected for the rat beta-3 adrenoreceptor were not full agonists of the human receptor. With that, I then wanted to go to a paper which the learned judge has held not only represents the common general knowledge, but is common general knowledge, which is called Yamaguchi. And the judge sets out Yamaguchi at paragraph 92, almost verbatim, at least the greater portion of it verbatim. And I was going to go to it in the original, which is in tab 12 of the supplementary bundle, mostly because it's much easier to read. The text is much larger. It's tab 12 of the supplemental bundle. And I think think we can pick it up using the bundle numbers at bottom of 185. There's a section which starts, last paragraph 185 explains that what the evidence is for the role of beta 3 AR in the relaxation of human detrusor muscle, explains the pharmacological studies, and then at the last sentence, just before the new title, it says, in all of these findings suggest that the relaxation induced by adrenergic, that's sympathetic, stimulation of the human detrusor muscle is mediated mainly through beta 3. Then it's explained just reading on, the in vivo effects of beta 3 AR agonists on bladder function have been studied in animal models. Relaxation of the rat detrusor muscle is known to be mediated not only by beta 2 but also by beta 3. So important to keep in mind that in humans relaxation was mediated mainly through beta 3, but in rats it's both beta 2 and beta 3, and there's evidence of that of my learned friends expert Dr. McMurray at 5.6 of his second report. Then dropping down to the next paragraph, although these results are encouraging for the clinical development of beta 3 AR agonists for treating overactive bladder, beta 3 AR agonists have already been used clinically as anti-obesity agents. Given that the activation of beta 3 AR on adipocytes, that's fat cells, lead to lipolysis and increase in energy utilization, several rat beta 3 receptor selective agonists that showed anti-obesity effects in animal studies were studied in humans. Unfortunately, these studies revealed that any therapeutic benefits derived from these agents were complicated by side effects of tremor and tachycardia, probably mediated by beta 2 and beta 1. These studies also indicated that pharmacological differences existed between the rat and human beta 3 receptors. Indeed, all of the beta 3 AR agonists tested in the clinic to date are only weak, partial agonists of beta 3 receptors and are not selective for the human beta 3 receptors. So a partial agonist, partial means unable to achieve full agonist activity, and not selective means that they're reacting with other beta subtypes, so beta 1 and beta 2, which can give rise to these undesirable side effects which are being described. And it continues, defining a treatment for the overactive bladder, they may therefore be dependent on the development of a beta 3 agonist that shows selectivity for the human beta 3 receptor. And dropping down to the end of that paragraph, about 5 lines down from the bottom, there's a reference to a compound, L555507, which was shown to be a selective agonist for the human beta 3 AR, with 1,000-fold selectivity for activation of this receptor versus activation of the beta 1 receptor, and no measurable beta 2 AR agonist activity. Given the high selectivity of L755507 for the human B3 AR, its agonist activity at the site, we determined its activity on human isolated detrusor muscle, pre-contracted with carbachol. And there's some data presented in figure 3, and they compare L5507, which is impacts beta 3. They also look at isoprotanol, which is non-discriminatory, goes for all 3 beta receptors, and clenbuterol, which is has selectivity from beta 2, and you can see is less effective. Just going back for a moment and just looking at the start of 186, the list of agonists there are not the human selective ones. Just noting, because it comes up later when we look at the patent, 177A, it was common ground that that was not a full agonist in humans. It was worked in in rats, but in humans it's only a partial agonist. And that was common ground. Pick that up. And then finally on this paper, just looking at the conclusion, human beta-3 agonist receptor appears to be a useful target for the therapy of overactive bladder and other disorders. Differentiating between compounds that have selectivity for human versus animal beta-3 is, however, an important consideration in the continued study of this receptor. The development of compounds that have high selectivity for human beta-3 AR will not only aid in the production of new therapeutic modalities, but will also help elucidate mechanisms. So, having looked at that, we can now return to the judgment. And so I'm now in paragraph 96. The judge has been through Yamaguchi, or at least set it out, and looked to the conclusion. And then at 96, he concludes one of the claimant's points was the idea of using beta-3 AR agonists for treating OAB had momentum. I agree with this. Significant results advancing the understanding of the role of beta-3 ARs in the bladder had been achieved in a period of just a few years leading up to the priority date, and suggestions for therapeutic potential had been made swiftly thereafter. It goes on to say this is something needs to take into account. Just wanted to draw your attention to paragraph 99. The increasing understanding of B3AR agonists in the context of the bladder must be tempered by the CGK fact set out in Yamaguchi that beta-3 agonists had failed in human clinical trials as anti-obesity agents even after success in animals. You've seen the reference to that in Yamaguchi. One possible reason for this, explained in Yamaguchi, was that the beta-3 agonists tested in the clinic were only weak, partial agonists of the human beta-3 adrenoreceptor and not selective for the human beta-3 adrenoreceptor. More generally, there was a lack of full understanding of the reasons. Overall, I think the CGK was that lack of clinical trials for beta-3 AR agonists for OAB were recognised as a gap in the knowledge of the art. They would probably come soon, and that they had potential, but their outcome was fairly uncertain. I now wanted to go to the patent, obviously going to come back to other passages in the judgment, but I now wanted to go to the patent, which is in the supplemental bundle. And my lords and my lady will see it has a 2003 filing date, priority 2002, November, and draw your attention to paragraph 4. So it obviously starts off paragraph 1, this invention relates to treatment of overactive bladder, comprising, and that's Meade. And then paragraph 4 says the present inventors reported in example 41 of the pamphlet laid open, 607, that, and then that's Meade, has both promotion action for insulin secretion and enhancing action for insulin sensitivity. Further has anti-obese and anti-hyperlemic actions, whereby it is a useful compound for the treatment of diabetes. But there is neither suggestion or for therapeutic use over the overactive bladder. Refer to patent document 1. So it gets a little bit complicated. So patent document 1, which is being referred to there, 607, is in Japanese, but it was published in Europe as the 111. To give my lord to my lady the full 1028 111. So it's published in Europe as that, and the 288 patent, the prior art in this case, is the Australian equivalent to 111. And there are no material differences with respect to the disclosure of mirabegron between either 607, 111 or 288. They're all the same. And both patent document 1 here and 288 disclose mirabegron as a selective human beta-3 agonist who do not disclose any data and do not disclose specific data points. So moving on to paragraph 13. The authors say that it's also, they refer to a compound, they say it's useful as a remedy for diabetes mellitus. As a result, they found the active ingredient of the present invention is useful as a remedy, particularly for use in the treatment of overactive bladder. Then at 14, drop down, characteristic feature of the present invention is that the active ingredient of the present invention mitigates especially the frequent occurrence of urinary urgency of the patient. Number of times of urination and state of urination are made into a more normal state. It goes without saying that overactive bladder in the present invention includes not only, and there's a list we need trouble with, and then there's again a reference to patent document 1, and then I think we can just go straight to the examples, see what it's done. And they performed one of these example ones right at the bottom of page 7 of the document, page 8 of the bundle. And it was one of these tests. They used both carbachol and potassium chloride in different tests, and looked at these strips of bladder in a bath. Looked at the contraction, or the ability of the mirabegron to inhibit the contraction. Important to bear in mind, this is rat strips, and the results are given in paragraph 30. As a result of the above test, the compound, which is the active ingredient of the present invention, showed a strong relaxation in antagonism test to contraction by carbachol, and antagonism test contraction by potassium chloride in an isolated rat bladder smooth muscle relaxation test. In addition, the compound A showed a significant strong relaxation as compared with 177A, which was the control compound, and then various data is provided. No dispute that it shows that. And then example 2, they look at, that's the top of page 10, they look at the rat rhythmic bladder contraction measurement test. Again, this is performed on rats, so this is filling the bladder and watching contractions. And then there's a further example, which is example 3, and again we don't have to, no dispute about any of this, I have to go to the details. Example 3 was one of these models where they put cyclophosphamide into the abdominal cavity, and then we're looking at bladder contractions and the ability of mirabegron to produce that. But again, all this is very interesting, but it's all in the rat. So if we look at the judgment, how the judge deals with this, we have no criticism really of this, but it's 126 to 137. And the judge takes it fairly briefly. As I say, there was very little dispute, so there's no criticism. Sets it out down to 126 through to 137. But if I could just draw 137 to your attention, that it should be borne in mind that all this work was done in rat-based models. There is no work relating to humans. There is also no test of whether mirabegron is selective for beta-3 in preference to beta-1 or beta-2, so there's no selectivity test. There's also no potency test. There's been no data generated to find out whether mirabegron binds to beta 3, how powerfully it binds to beta 3. They miss all that, and they just go straight saying, does it interfere with a rat's bladder? So on the face of the patent, what the patentee has done is taken a known human selective beta 3 agonist and shown it has the capacity to reduce bladder contractility in rats. The patentee has not tested whether it's a selective human beta 3 agonist, as is taught in the prior art. In fact, it's not tested whether it's a beta 3 agonist at all. A patentee has not tested whether it has any capacity to interact with the human adrenoceptor, whether it has any efficacy on any human tissue whatsoever, including human bladder. And the patentee obviously has not tested this in the clinic. My lords and my lady, if I could then go to the prior art, which is at tab 2. And then the supplemental bundle, same bundle we were into the patent. And of course you've seen a reference to, in the patented suit, to a patent in the same family, patent document 1, they say this is the Australian equivalent. And it starts off setting out the technical field, and it is indeed in relation to therapeutic agents for diabetes mellitus, which you get on page 21. Then if we go to page 23, it talks about the problem, top of the page, talking about prior art says, unfortunately those beta 3 agonists of us also have actions caused by stimulation of beta 1 and beta 2 receptors, such as increased heart rate and muscular tremor. These are prior art compounds. And they have a problem in terms of side effects. Recently it was ascertained that beta receptors have differences to species, and it has been reported that even compounds having been confirmed to have a beta 3 receptor selectivity in rodential animals, such as rats, show an action due to stimulating beta 1 and beta 2 receptors in human beings. In view of the above, investigations for compounds having stimulating action which is selective to the beta 3 receptor in human beings have been conducted recently using human cells or cells where human receptors are expressed. And then there's disclosure of the invention on page 24, and they say they've conducted an intensive investigation looking for compounds that have insulin secretion promoting action and insulin sensitivity potentiating action, found that novel amide derivatives show both good insulin secretion promoting and good insulin sensitivity potentiation action, and furthermore show a selective stimulating action to the beta 3 receptor. Then they set out a Marcouche formula, and just looking, they describe its structure, and it's picking it up right at the bottom of 24, last 3 words. It says having both an insulin secretion promoting action and an insulin sensitivity potentiating action, and further having anti-obesity and anti-hyperlipemia actions due to a selective stimulating action to beta 3 receptors. And then if we go to 38, actually should pick it up perhaps the 35 first. We've got a section starting industrial applicability, and there's quite an inconsistent use of singulars and plurals throughout this document, not only in relation to the compounds but in relation to other matters also, but that may be a translation thing, but I don't think anything turns on it. They talk about industrial applicability at the middle of 35.
Where are you on page 15, 35 of the bundle? Yeah,
exactly. Just see the title, just bring up the title. Yep. I'm actually going to go to the next page and look 4 lines down. The beta 3 receptor stimulating action of the compound of the present invention is selective to beta 3 receptors in human being. And then And there's a list of diseases, and as the judge has correctly noted, OAB is not in the list of diseases. We then need to look at the examples, how they've investigated this, and they start on 38, and there are 2 tests performed in mice which are to do with diabetes, in which we don't rely upon. There's you see a hypoglycemic test, page 38, and then if we turn over the page, halfway down we see a glucose tolerance test. But we're interested in the 3rd example, and this is where they determine the products are, or the drugs are, selective human beta-3 agonists. And that's so in the middle of page 40, stimulating test to human beta-3, beta-2 and beta-1 receptors. And they say human beta-3 stimulating action was investigating using an SKN-MC cell system, cells in which the human beta-3 receptor and the human beta-1 receptor was permanently expressed. And they then, they have some other cells which are beta-2 and beta-1, but then dropping down 6 lines from the bottom, they say, incidentally, the human beta-3 stimulating action was investigated in the presence of a beta-1 blocker. So they block the beta-1 receptor, and then any activity they're seeing is specific to beta-3, sorry. And just at the bottom, and they say intensity of action of each compound was compared by calculating PD2 value, maximum activity, and they had a resulting dose reaction curve. It has been ascertained that the compound of the present invention has a selective stimulating action to the human beta-3 receptor. So that's the methodology that was used. And if we work through to 43...
I'm sure I'm missing something, but you pointed out that there's a beta-1 blocker. How do you know it's selective as against beta-2?
Because this particular cell line just expresses beta-1 and beta-3. And then they had another cell line which...
oh yes, I see, right. Yeah,
okay. So you
Thank you.
Make deductions from that.
Yeah.
Sorry, my lord, I may be taking this too quickly.
That's all right.
And then I wanted to pick it up at 43. The present invention is further illustrated by way of examples hereunder. Compounds of the present invention are not limited to those mentioned in the following examples. Then if we look at the examples, example 5, which one sees on page 45, is in fact mirabegron. So the method of manufacture is given there. And then at 46, middle of the page, they say the structural formulae of the compounds for the examples are given in table 1. Physical and chemical properties of the compounds of referential example 1 are given in table 2. And physical and chemical properties of the compounds of the examples are given in table 3, respectively. And then you see on the table on the next page, 47, you see you have example 5, which is mirabegron, one of 6 examples. And then on table 3, you have the NMR data. So plainly it was made, but of course we accept that the data has not been provided for example 5.
Mr. Turner, if I'm expected to understand the contents of table 3, you're going to have to do a bit of explaining.
I think it's my Lord Justice Arnold knows far more about this than I do, but it's a technique used in chemistry to identify what product you have been produced, called nuclear magnetic resonance. And it would take us probably the rest of the day to explain it. And I'd have to sit down and let Mr. Barron do that, but I don't think we need to know the details. Suffice it to say, that satisfies my Lord's curiosity for now.
Certainly.
Then, my Lord, if my lady, if we could go to the judgment at 159. So this is where the learned judge is working his way through the teaching of 288. And then he deals with the third experiment at 159. The third experiment is done in cell lines expressing human beta receptors. Which cell lines were used. What was tested for was the stimulating effect on cyclic AMP production. The authors say at the foot of page 20, intensity of action of each compound was compared. So in the instance, it appears that more than one compound was tested. Over on page 21, there is a statement: it has been ascertained that the compound of the present invention has a selective stimulating action of beta-3 receptor. There's no numerical data, that's correct. This is the result Dr. Argentieri called compelling, which in my view, given the context, may seem to be a significant overstatement. And then if we pick it up at 167, having considered the evidence, what the text on page 20 means is ultimately a matter for me and not the experts. The reality is that it is not at all clear, leaving aside the semantic clicking around of the compound of each compound. And as I say, we can see that the plurals and singulars are awry in the document. It says it is striking that in just one instance, actual numerical data is given for a compound, example 6. And that was the data for example 6 is in the first experiment, not the example.
Sorry, can you just show us where that is in the data?
Yes.
Just
so that's
so we
if we
can
go back to tab 2, and I think it's so the examples start on page 38.
Yes.
That's the hyperglycemic test, and they put a data point in for example 6. On the next page, 39, about line 10, for example, the compound of example 6 showed a hyperglycemic rate of 48% in the oral administration.
So that's it.
That's the one that the judge is referring to.
I see. Thank you.
So the data points, and the point the judge is making, and it's a fair point, the data points, for example 3, which is the only one we're really interested in this case, the data points aren't there. Just the teaching, the beta-3 selective agonist. So although they give the methodology...
So the data Marlon was asking about is the description of the compound, but...
Yes, so the NMR data, that's quite right. So,
yeah.
so the 6 examples are drawn out.
Yes.
There's no dispute that you're told how to make them.
Right.
The data in table 3 is just data relating to what they look like.
What the compound
is.
I see.
And there's no data relating to selectivity. So it's a teaching of selectivity, but no data is supporting that teaching.
It might be worth explaining that this is a not uncommon phenomenon which gives rise to quite a lot of disputes in patent cases, which is that we find in test 3 at pages 40 to 41 a description of the test method, and then we find at page 41 in the second paragraph the statement: it has been ascertained that the compound of the present invention has a selective stimulating action to beta-3 receptor, but supporting data for that statement are nowhere to be found.
Yes, my lord's come across this before.
Yes, I have.
So if we would be discussing this, if we were dealing with the validity of 288, this would be a serious concern. And my Lord Justice Arnold has given an important recent judgment on this very area.
So, if you like, is it fair to describe the data as explaining how it would explain how selective, or?
So they say it's a beta-3 selective compound. They say this is the way it was measured, but they don't include the data, so you can't tell.
What I'm just trying to understand is what would the data show?
The data would be a figure of a particular potency figure.
I see. Thank you.
potency figure against, you've got similar data. It may just be helpful. So if you go to
So the
Yamaguchi,
one example you've got here on page 19, page 39, that looks like, is that a potency?
no, it's nothing. It's to do with a specific measurement to do with using the drug for diabetes. So the sort of data that one, if it was presented, and if I could just go back to Yamaguchi. Which is actually not quite the same, but if you go to page 186, so it's tab 12, page 186. This is the, they've looked at compounds. So down the left-hand column, you've got 3 compounds: isoproterenol, clenbuterol, and 507, and they've looked at its ability to activate beta 1, beta 2, and beta 3. And
unhelpfully, the copying has blacked out the graph.
sorry, I'm on the right-hand side.
So you're talking about the graph at the top of the page on
186. Should look at table.
Yeah.
Like
Oh, right,
table.
table 1, yeah.
Sorry, man.
So that is
right.
the sort of thing.
That's the sort of thing, and you
I
can see. So if you low numbers means a lot of activity. So if you look at isoproterenol, if you look at the K-ACT, which is probably the better one because that's the activation. Yes. You've got a low figure for B1, you've got a low figure for beta 2, you've got a low figure for beta 3. So it's active against all those 3. You look at clenbuterol, it's well, lowish. It's actually just got binding, so ignore that one, but it's not got the K-ACT, I noticed. But 507, the K-ACT is very low for B3, and that's why they're saying it's selective. Does my lady see that 0.43?
Yes.
Whereas against B2, it's 1,000, more than 1,000, so almost no activity. And then beta 1, it's manyfold higher on beta 1, so less effective on beta 1 than it is beta 3. So that's the sort of data one would get if one did experiment 3. But what the patent, and it cuts both ways. It cuts to the patent. Neither the patent nor 288 have data showing you what the specific potency is, what the figure is, and it applies equally. But and although that would be a criticism if we were looking at the validity of 288, we're not doing that today. What we say is plainly the authors have put forward mirabegron as an example. Plainly the authors are teaching it's a human selective beta 3 agonist. And it's not suggested by the learned judge that teaching would be rejected. So we say mirabegron has been disclosed in the prior art, it's old, and it's been disclosed as a human selective beta 3 agonist. And what you don't do is for a patent, get a patent for just confirming what already has been taught in the art. So if you came along and tested it and say, aha, I can now tell you it's a beta 3 agonist because it has this potency, you wouldn't get a patent for that because that's already old. And in any event, the patent in suit in this case doesn't do that either. Okay. So all the patent in suit relies on is by pointing to patent document 1. And patent document 1 is materially the same as 288. So it just takes you back to the same place. And similarly, we say if the common general knowledge is that a human selective beta 3 agonist is known to have potential use in the treatment of OAB, then it cannot be inventive to take a known beta 3 agonist and just make that suggestion. And insofar as there was uncertainty with regards to the potency of mirabegron or the absence or uncertainty created by the absence of clinical experience, those are not matters, those are not relevant matters in assessing inventive step in this case. And that's where we say that the judge has gone wrong. Now what I was proposing to do next, I've done the sort of heavy lifting, so to speak. I was going to go to the authorities and then I was going to start looking at the judgments in detail. So I was going to go to Zolli first. So the principle, just to remind you again, I said at the outset, is that insofar as a patentee relies on a perceived problem in the art to support a case of inventive step, that problem must be plausibly solved by the patent. And we say this naturally flows from the well-known principle that a patent monopoly should not exceed the technical contribution of the patentee. And this was considered specifically by Justice Jacob in Zolli, concerned whether there was a prejudice against packing CDs so that they touched each other. The judge at paragraph 25 deals with lines in the path, and just states, we need to take this carefully, so I would not analyse it among yourself. There is an intellectual oddity about anti-obviousness, anticipation arguments based on technical prejudice. It is this: a prejudice can only come into play once you have had the idea. You cannot reject an idea as technically unfeasible or impractical unless you have had it first. If you have had it first, how can the idea be anything other than old or obvious? Yet when a patent demonstrates that an established prejudice is unfounded, what was considered unfeasible does in fact work, it would be contrary to the point of the patent system to hold the disclosure unpatentable. And then he cites himself from Union Carbide, invention can lie in finding out that which those in the art thought ought not to be done, ought to be done. From the point of view of the purpose of patent law, it would be odd if there was no patent incentive for those who investigate the prejudice of the prior art. Patentability is justified because the prior art which was thought not to work must, as a piece of prior art, be taken as it would be understood by the person skilled in the art. He will read it with the prejudice of such a person. So that which forms part of the state of the art really consists of two things in combination: the idea and the prejudice that it would not work or be impractical. So just pausing there. So if the ideas of beta-3 agonists were in theory known but thought to be impractical, we'd be engaging the learned judge's thinking.
Does it have to be prejudice in the way that that word is normally used? I mean, there may be an actual technical blockage which someone subsequently unblocks.
Yes, of course you can have those cases, but in this
but that would still be described as prejudice.
Well, in this particular area, the judge was concerned with two CDs. Could you pack CDs next to each other? People would think, oh, that's not a very good idea because the CDs might
they're going to scratch each other.
And the judges would go on to see, says, well, look, that can't be relevant to inventive step unless the patent has solved that problem. That problem remains when the patent is granted, as it did in the prior art. That can't be a relevant factor.
But for the purposes of the principle, it wouldn't matter whether it was a prejudice that people had this belief, unfounded as it may be on technical basis, that putting two CDs into a single wrapper might scratch them, or whether there had previously been some technical problem with CDs that if you do certain things with them, they did actually fall apart.
So the judge considers two possibilities. He considers lines in the path and those that turn out to be real problems, and those that turn out to be illusory. He calls them paper
remains a line.
He says in both cases the solution must be in the patent. That's the bit we're going to come to. So again, picking it up in 27, the second sentence, so that which forms part of the state of the art consists of two things in combination: the idea and the prejudice that it would not work or be impractical. A patentee who contributes something new by showing that contrary to the mistaken prejudice, the ideal will work or is practical, has shown something new. It's shown that an apparent line in the path is merely a paper tiger. Then his contribution is novel and non-obvious, and he deserves a patent. So dispelling myths, put it that way. Where, however, the patentee merely patents an old idea, thought not to work, or thought not to be practical, and does not explain how or why, contrary to the prejudice that it does work or is practical, things are different. Then his patent contributes nothing to human knowledge. The line remains at least apparent, it may even be real, and the patent cannot be justified. And then I was going to pick it up in ACES Tech. This gets...
Yes, I appreciate you're on the law at the moment.
Yes.
So I'm not asking for an immediate answer to the question I'm about to ask, but since it's in my mind, I'll ask the question now and then you can answer it later, which is, what do you say was the lion in the path that Astellas were relying upon as negating obviousness in the present case?
Yes, and my lord, I can answer that straight away. There were two things. First of all, general uncertainty that beta-3 agonist therapy would work for treating OAB. So there was general uncertainty to the approach pending clinical trials. And my lord has seen in Yamaguchi, we need clinical trials. The other thing is the question mark over the potency and the beta-3 selectivity of mirabegron. And the patent doesn't teach anything about that at all. So it has no measurement of potency, and it doesn't expose mirabegron to human tissue. So those are the two practicalities that are of concern from the prior art. Is this suitable as a clinical approach? And secondly, is mirabegron one of those beta-3 selective human agonists that papers like Yamaguchi...
That's a helpful indication at this stage, but when we get into the detail, you're going to need to explain to me why either of those things are properly characterised as prejudices.
Yes. So, as we say,
and I appreciate your argument is that to the extent that prejudices, the patent doesn't overcome them. I appreciate that, but to understand the relevance of Pozzoli, I need to understand why there are prejudices in the first place.
Yes. So I just pointing out that Lord Justice Jacob talks about the idea and the prejudice that it would not work. So this is looking in the middle of 27, all being practical. So it's not a formal, doesn't have to be a formal prejudice. It doesn't have to satisfy particular criteria before it becomes a prejudice. And we say that it applies, we'll have a look at ACES Tech to see how it's put in ACES Tech. So it's not only engaged when you've achieved the threshold of the prejudice. Anything, it might be a concern about side effects, might be concern about lack of efficacy. These are all different types of concerns, lack of practicality, and that's how prejudice has been used in that sense. And that's apparent from ACES Tech, we say. So if you go to tab 10, paragraph 59, that we just see that Pozzoli is cited there. I don't need to reread that. And then I was going to pick it up as 73. Finally, the defendants contend that the issues, the issues which the judge would have deterred the skilled term from proceeding to implement SHAD at the base station remained issues for the implementation of the 252 patent, in the sense that the patent did not teach the skilled person how to overcome them. This is the point based on the passage from Pozzoli, which I've cited above. The principle is you cannot have a patent for doing something which the skilled person would regard as old or obvious, but difficult or impossible to do, if it remains equally difficult or impossible to do when you have read the patent. To put it another way, the perceived problem must be solved by the patent. So this doesn't just apply in our submission to a subset of cases where there's a threshold prejudice. This applies to any case. And the one that's sort of run out most frequently, in my lord will be aware, in patents to pharmaceutically active compounds, is say, well, it might cause side effects. You haven't shown it hasn't caused side effects. When you've got the patent hasn't dealt with side effects either, and then that's not a relevant factor when it comes to comes to testing inventiveness.
The reference to the perceived problem there is a reference back to the word prejudice used in Pozzoli, is it?
Yeah.
Or that's the context.
A problem with the prior art. So the problems in this case with the prior art are, one, people just were optimistic, but they weren't sure that beta-3 agonism would work.
Okay, I think this may come back to the same question we were asking a couple of minutes ago.
It may come back, but it's an important question. And then the other one is that, well, nobody knows how active mirabegron is at the beta-3 human receptor. And our submission is that this approach, this is an important approach. We also see a similar thing. We just draw my Lord's attention and my lady's attention in the case law books of the Boards of Appeal. So that's at tab 12. 355 of the bundle. Just looking at the top, according to the established case law of the Boards of Appeal, alleged advantages to which the patent proprietor applicant refers, without offering sufficient evidence to support the comparison with the closest prior art, cannot be taken into consideration in determining the problem underlying the invention, and therefore in assessing inventive step. So the patentee doesn't get free beer. And we then need to go to Connor, because that's the case where clearly the judge saw was in tension with this approach. And we need to go to tab 5.
But you don't think there's attention? No,
we don't. There's attention. And we think the judge was wrong not to apply ACES tech. He only applied it very narrowly.
Did you think there was attention when you applied for permission to appeal?
Well, we thought he misapplied ACES tech because the judge was applying attention with Connor. So the way the judge analyses it. So sorry, if my Lord is asking my submission is there's no attention. But the judge misinterpreted Connor and used it to sort of trump aspects of ACES tech, if I can put it that way.
Thank you.
So we just need to take this a little bit carefully because it's a complicated case. So if you look at 717, you see what the claim is to. Just at the top, it says it's a stent. My lords and my lady be familiar with a stent is a piece of metal that goes into hold an artery open. A stent for expanding the lumen of the body passageway, comprising a generally tubular structure coated with an anti-angiogenic factor and a polymeric carrier, factor being anti-angiogenic by the CAM assay, so it's anti-angiogenic, and then it's limited further, and it has to be Taxol. So it's effectively a stent with Taxol in a polymeric carrier. And the problem that the patent is concerned with is a thing called restenosis. So somebody has a reduced lumen in their artery, typically put in a stent that expands the lumen. But you can end up, there's a major problem with what they call restenosis. So you get a reaction in the artery and then it starts closing up again because of the presence of the stent. Just before we get to the judgment, if I can just give you a couple of background facts to the case. Taxol was known to have anti-cancer properties because it slowed cell division. It's an important treatment and became an important treatment for ovarian cancer. A criticism was made of the patent that it did not contain any clinical trials of Taxol, and in that sense this was all speculative. However, there's no analogy really with the Pozzoli case or the circumstances of this case given the following background. I'll just explain this briefly. So the closest prior art in Connor was a drug-eluting stent. So it was a stent with a polymeric material that would release a drug, but it didn't refer to the drug which would be useful in stopping restenosis. There was another piece of prior art, Katsuda, that's Wolf, another piece of prior art, Katsuda, which mentioned Taxol in the context of its general anti-cancer activities, its mitogenic activities, but had nothing to do with restenosis and said nothing about its anti-angiogenic properties. So there was no teaching in the art that anti-angiogenic drugs, and we'll come on and see what those are, were suitable for treating restenosis. That wasn't in the art. And nor was it in the art that Taxol was an anti-angiogenic drug. And then the final bit of background, which one can see at paragraph 36, it was not contended that the patent did not render plausible the use of Taxol. Now with that background, if I can just go to the judgment, so one can see that the problem is set out in paragraph 7, and the state of the art before the patent. There's an article, at least it's a helpful article, and it said, despite 15 years of clinical experience and research in the field of restenosis prevention, this has not yet resulted in the revelation of an unequivocal beneficial effect for any drug. Other new approaches likely to receive more attention in the future include antibodies to growth factors, gene transfer therapy, antisense oligonucleotides. Whether there is a feasible monotherapy, whether we have to focus on a drug combination, whether we're only searching for the holy grail, remain to be answered. So the art was a bit of a problem. Then it explains that in Vancouver, a medical student, Hunter, was studying angiogenesis, and angiogenesis is the prevention of the growth of blood vessels. So it explains that process by which capillary blood vessels grow. Under that gentleman who made a particular area of research, it occurred to Dr. Hunter, one approach to unwanted cell proliferation might be to inhibit angiogenesis, because most cell tissues cannot grow more than 200 or so microns without blood. Just dropping down in 1991 during his third year in medical school, he met Dr. Macken, who had experience in cardiovascular intervention and the use of stents. As a result of their discussions, they tried to find an antiogenic agent which could be used to prevent restenosis. In the next paragraph, they say they tested various drugs by using the CAM assay, which you've seen referred to in the claim. It uses a chick embryo, and you can see blood vessel growth in the chicks. This was an established test, although perhaps not very sophisticated. One of the drugs tested in February was paclitaxel, that's Taxol, a recently discovered anti-proliferative derived from yew tree, which was in the news as a cancer treatment, dissolved in chromophore. It was marketed under the trade name Taxol. On the CAM assay, it appeared to have remarkable antiogenic properties. Dr. Hunter said it was effective to inhibit angiogenesis, even in minute concentrations. So then if we go to 15, Lordship is saying this seemed a fairly straightforward issue. Angiotac, no doubt prepared for trial, clutching the Holy Grail paper as the best possible evidence that there was at the time no obvious solution to restenosis. But then events took on a different turn. In the skeleton argument served at the end of September 2005, Mr. Thorley for Connor denied that the inventive step disclosed by the specification was to coat the stent with Taxol. It was, he said in paragraph 62, much less precise. The inventive concept purportedly resides in the idea of seeking to treat or prevent restenosis by coating a stent with the Taxol polymer composition. This disclosure is of no more than this. The idea is not shown to work, nor to work in any particular extent, nor to work with any particular polymer, nor with any particular amount of drug. The invention thus lies in the idea of trying one or more Taxol polymer combinations. on that basis, the patent taught no more than Taxol was worth trying, he submitted, and that it added nothing to existing knowledge. Just pausing there, I mean, one has to bear in mind the prior art was miles away. No one had even identified Taxol as having these properties. And then it was common ground that Taxol was, like many other antibiotics, worth a try, and was obvious. It was not necessary for Connor to show that it was obvious actually to use Taxol to teach restenosis, as the patent did not teach that it would work. I shall say at once that, in my opinion, this argument is an illegitimate amalgam of the requirements of inventiveness and of sufficiency. And then at 19, in my opinion, however, the invention is the product specified in the claim, and the patentee is entitled to have the question of obviousness determined by reference to his claim, not to some vague paraphrase based upon the extent of his disclosure in the description. And then you should have a look at 36, because I said I'd show it to you, the specification. That's just where the court notes Connor did not suggest that his claim is not plausible. So now we say Connor is consistent with Zolli and with Asus Tech. In both cases, and on our approach, in both cases one is asking, is the invention as claimed, stripped of unnecessary verbiage, obvious? The question of inventive step, depending on unslayed lions, or of potential concerns, potential uncertainties, did not arise in Connor. And the reason it did not arise is that it was not known or obvious that Taxol was an outstanding anti-angiogenic compound, or that anti-angiogenic compounds were plausible ways of treating restenosis. The patent showed it in that case to be an outstanding angiogenic compound by reference to testing which took place, and advanced this as a way of preventing restenosis. So there was a clear technical contribution, and a technical contribution which was plausible. Now in this case, we're in a very different territory. In this case, we have beta-3 agonism as a known approach to treating OAB. And we have mirabegron disclosed in the prior art as a human selective beta-3 agonist. And that does engage Asus Tech, because the question, what's put against us is, although beta-3 agonists was a plausible approach to treating OAB, or a possible approach, or a plausible approach, it's not, there was uncertainty around it until you do clinical trials. And of course the point we're making is, well, the patentee didn't do clinical trials, how can the patentee rely on the absence of clinical trials? It's not paraphrasing the claim, it's just saying you can't rely on a problem you haven't solved. And then similarly it said there's doubt whether mirabegron is a human selective beta-3 agonist. How does the patentee show it's a human beta-3 selective agonist? The patentee just points to 288. Not exactly 288, it's another patent in the family. But nowhere is there data that it engages the receptor. Wonders, I don't know if we're having a 5-minute break for the...
We don't normally break.
Oh, we don't break. So, again, at the risk of repeating myself, the patentee does not measure mirabegron's human beta-3 agonism, does not expose human bladder streaks to mirabegron, or another way attempt to measure the effect of mirabegron on human tissue. So, if I can then go to the analysis of inventive step in the judgment, and pick it up at the law first. judge refers to Connor and Angitech at 31, and then at 32 says the reason I refer to this is that during cross-examination it was apparent that the claimant's obviousness case was in part being advanced by reference to what were being said to be limitations in the experimental proof in the patent, until to a greater extent the priority document. And then dropping down to the extent that such cross-examination elicited statements of technical opinion, themselves relevant to the real issues of obviousness, that is fair enough. But a lot of questions were along Connor lines. The experiments in the documents were limited, as they proved compared to the experiments in the prior art or the CGK. And as we say there's no inconsistency with saying, look, the patentee hasn't demonstrated A, so you can't rely on A as part of your inventive step or for your inventive step. And then the judge then refers to Phillips and Aces Tech, and then at 35 the judge says, in the present case there is no doubt that the skilled team in this field would have a keen awareness of the likelihood and risks of side effects with any mechanism, including beta-3 AR agonism, and their main potential cause of side effects for beta-3 AR agonist under consideration will be off-target effects. And then he goes on, but since the patent contains nothing to say as to whether or to what extent mirabegron was selected for beta-3 or beta-1 or beta-2, Astellas cannot rely on this as its counsel accepted. Astellas did argue that urine retention would be a side effect of concern and did so on the basis the patent does address it. The point therefore depends on the facts. So the judge is quite correctly alive to the Aces Tech point insofar as it engaged side effects, because selectivity has not been demonstrated by the patent. But he should have taken the same approach to uncertainties with regards to efficacy. It wasn't just limited to side effects. But the learned judge should have said, and also, the patent does nothing to solve the problem of uncertainties around beta-3 agonist activity generally as a treatment of OAD. Does not, in fact, disclose the potency or determine the potency, if any, of mirabegron for beta-3 activity, save to point to the prior art. Now the judge then at 174, I'm going to jump forward to look at I'm going to come back to other passages, but I want to go to the heart of things initially. And that's at 174, where the judge sets out the parties' key points. Nature of the claimant's case is that it was CGK that's selective. Of course, that's human selective, not rat selective. Human selective beta-3 agonists have the potential to treat OAB. There's a shortage of potent human selective beta-3 agonists. Therefore, when in the context of the skilled team saw some selective beta-3 agonists that would be of interest, it would therefore be obvious to test 6 compounds. It would be obvious to thereafter to take those that succeeded, or at least mirabegron, into clinical trials with a reasonable expectation of success. He says that's his paraphrase, and describes the case quite correctly as we put it. The claimant's case is straightforward. They submit that by the priority date it was part of the common general knowledge that beta-3 agonists have the potential to be used in OAB. That consequently it was obvious that compounds disclosed as beta-3 adrenoreceptors were potential therapeutics. Mirabegron had been disclosed in AU208 as a beta-3 adrenoreceptor. It follows that's a human selective, again, occasionally the words just get missed out. And it follows that no technical teaching could reside in identifying it has potential for use in treating OAB. And then at 177 he deals with Astellas' key responses, and it might be helpful just to give us our responses as we go through them. Beta-3 agonism was just one of a number of possible ways of treating OAB in the art, and we say yes, there are other approaches. I think the judge agreed with this, but this was an approach with considerable momentum. And there are, then at Roman 2, there are no clinical evidence yet beta-3 agonism would work to treat OAB. This is correct, but that's the position after the patent has been filed as much as it is before. Still always going to be a measure, it's just a measure of uncertainty, pending performance of clinical trials. And this is, we say, engages the ASOSTEC point. Beta-3 agonism has been unsuccessful in the obesity field. My lords and my lady will have recalled that that's a reference back to Yamaguchi, and Yamaguchi put forward as one of the problems is there weren't human selective beta-3 agonists in those trials in obesity. And then 288 is not about OAB, that's correct. 288, this is 5, gives no information about mirabegron's activity. Same for the patent. The patent has no information about mirabegron's activity at the human receptor, just these rudimentary tests in rats which cannot be extrapolated. And then Romans 6 gets rejected by the judge, does not improve the confidence and rationale, and we said this, the patent doesn't either. And so we see a slight perhaps inconsistency in the judgment, as we'll see when we come on. 7, beta-3 agonism were to be pursued. There were many more attractive to compounds to choose from. Mirabegron, as the judge holds, there are only actually one common general knowledge compound which falls into that category, other than mirabegron, and the others in the patent, in the prior art rather, beg your pardon. And then at 8 gets rejected, so we don't need to focus on 8. And then I wanted to then go to, I'm going to come back to how he deals with the cross-examination, but I wanted then to go to the assessment first, so that we can see how the errors arise. And at 193, this is having had the submissions from the parties considered the cross-examination. I said I'm going to come back to it, but the judge says it's true that at the priority date, beta-3 AR agonism mechanism had momentum relevant to OAB, arising from recent advancements in the understanding I've identified in relation to the CGK, and hence beta-3 agonists had, in a general sense, potential as agents to treat OAB. And obviously, we place considerable reliance on this. So you have a general sense of potential, and here you have mirabegron being put forward as a beta-3 selective agonist. Where's the scope for invention? And then 194, however, the claimant's case suffers from 2 defects of overstating the confidence will be given to the skilled addressee and of oversimplifying the situation, in particular to the effect that any beta-3 agonist would be likely to succeed as a treatment. So we have 2 defects which the judge attaches weight to: overstating confidence and oversimplifying. We need to look at them. And again, just be careful, it's never our position that it's any beta-3 agonist. It's a selective beta-3 AR, a human selective beta-3 AR agonist. 195, so he deals with the first of his 2 defects. As to overstating the skilled addressee's confidence in beta-3 AR agonism for OAB, bear in mind that the mechanism has not been used successfully in any drug for any condition, and it had failed for diabetes. While these were potential reasons for this, that would leave open the possibility of success for OAB is not a good starting point for the claimants. So just to remind you, the failure in diabetes, we can bring it up again if we need to, but the failure in diabetes was attributed in Yamaguchi, which is the only place it arises. But we should just quickly remind ourselves. Tab 12. If you recall, it was the passage bridging the 2 columns in 186. Unfortunately, there's 4 lines down in the right-hand column. Unfortunately, these studies revealed that any therapeutic benefits derived from these agents were complicated by side effects of tremor and tachycardia.
Right.
I'm sorry, I'm 186, top of the right-hand column, 5 lines down. The word unfortunately.
Yep, thank you.
Unfortunately, these studies revealed that any therapeutic benefits derived from these agents were complicated by side effects of tremor and tachycardia, probably mediated by B2 and B1. So this is lack of selectivity. These studies also indicated that the pharmacological differences existed between the rat and human receptors, so therefore beta-3 receptors. Indeed, of all of the beta-3 agonists tested in the clinic to date are only weak partial agonists of the human receptor. So this was the problem Yamaguchi was putting forward. And as I say, this is common general knowledge, accepted to be common general knowledge.
Two problems, isn't it? I mean, it's selectivity in 2 dimensions. It's selectivity as between beta-3 and beta-2 and beta-1, and then selectivity as between human and rat.
Exactly. So, returning back to the judgment, that's what the judge is referring to in 195. And then at 196, as to the clinical prospects for OAB, the review papers, examples of which I have given above, certainly said that clinical trials were needed for beta-3 AR agonists, the condition. But my overall assessment of those, as I have touched on already, is that the authors were saying that the clinical evidence, what was missing and should be looked for, not that it would necessarily fall into place. So there was uncertainty around clinical trials. Doing those clinical trials would be an exercise in hoping to find something new and promising, not a routine matter with a strong, clear expectation of positive results. So until you get a beta-3 agonist into the clinic, there is a measure of uncertainty. And what the learned judge is doing here, we say, is making the mistake, falling into error, and because there are uncertainty with respect to clinical trials after the patent's been published, not addressed one jot. There's nothing in order to improve one's confidence generally, or one's confidence specifically with regards to mirabegron. And what's clear is this is a key aspect of the judge's rejection of the obviousness case, and it gets repeated and repeated, as we shall see as we go through. I also think appropriate caution would be seen by the skilled addressee as evidenced by the large number of possibilities in play to improve existing treatments of OAB. Some companies were exploring B3 agonisms, but others were not. And then at 198, so I thought Dr. Mills and Dr. McMurray gave a much fairer impression of the state of play in seeking to improve OAB treatments than did Dr. Argentieri. It is possible that beta-3 agonists would work for OAB, and it was possible that they would not. The same could be said for a number of other mechanisms under consideration for OAB that I have touched on. And again, it's the same point. This general uncertainty with regards to beta-3 agonism as a therapeutic approach is not addressed. There's no contribution in the patent which starts to address this. Nothing at all.
Okay, can I understand a bit better? I understand your point, but what the judge is doing here is saying this wasn't an obvious line of inquiry. This wasn't. It wasn't obvious to try. Going to the point that in assessing obviousness, one of the things you take into account is the number of possible avenues.
Yes, he doesn't place particular reliance on the number of different avenues. It gets the briefest dimension in this analysis. And of course, again, problem with the patent. He says that. So he says two things. First of all, he says beta-3 agonism is an approach which had momentum. So it was an obvious approach in that sense.
Well, he doesn't use that term, obviously.
He says it has. If you could just stop mumbling at me, so make submissions. So beta-3 agonism, he said it was an approach which had momentum. And perhaps we should have a look at it.
Yes, you've seen that.
Yes, you've seen that. And insofar as there is clinical uncertainty around that as an approach, this is where I make the submission, well, the patent doesn't resolve any of that.
Right.
How would you resolve that uncertainty? You'd resolve that uncertainty by doing a clinical trial. So if my learned friend had come along with a patent which had a rudimentary clinical trial, maybe 20 patients.
But put like that, you do then run into Connor, don't you? So
well, you don't. You don't in my submission. So you have to judge it by reference to the claim. So I think reading between the lines, if I'm allowed to do that with a judgment, I think what the judge has done is the judge has looked at the claim in this case and said that efficacy is an element of the claim, but side effects are not. So when I'm dealing with Connor, when I'm dealing with ACES Tech, I'm allowed to disregard side effects because side effects aren't claimed. That seems to be his thing. But when I'm dealing with efficacy and clinical approach, I have to start with the claim and I have to accept that because it's plausible. That's all I need to. I then have to ask, well, was it plausible? Was it obvious from the prior art?
So you think the only prejudice he's addressing is the side effect?
Yeah, he's addressing the side effects, I think. But he should, what do we say, is just as a fundamental, and it's almost a matter of common sense. If I say, let's take an example. I give you, and it's not far off this case, my lady. I hand you a compound and say, this is a good beta-3 agonist. And you think to yourself, people have been speculating beta. I'm going to use the word speculating for my example. People have been speculating on beta-3 agonists for OAB. And then you file a patent saying beta-3 agonism. This compound that I've just been handed, being told it's a beta-3 agonist, I claim this compound for treating OAB. You have done nothing more than write down on a piece of paper that which was in the art. And that's essentially, we say, what's happened here. There's a slight distraction, because what my learned friend does is he puts it in a rat bladder and does some experiments on rats. As we shall see.
But that's the point of my lady's question, because the argument against you is that the rat bladder in the present patent is precisely equivalent to the CAM assay in Connor.
Yes, but as we see when we get to the evidence, it's not. I mean, that's the thing. If the rat gave an indication of, but when we're talking about the clinical uncertainty, the rat work had been going on for ages. We've seen it in Yamaguchi. Lots of people have done that work on beta-3 agonists.
Not with this compound.
Not with this particular compound, no, but they've done it with other compounds. But the clinical uncertainty my Lord is talking about, the learned judge is talking about, clinical uncertainty is a general one. He's not at this stage focusing on mirabegron at this stage. So if you look at what he says,
now, yes, I've read that. So
196,
yeah,
my lady.
well, I've asked my question.
So 196, it's a general. We're going to come on to his when he gets to mirabegron. It's a general concern that clinical trials haven't been done at all. So if you take that logic, so what had happened is lots of these compounds have been put in rats. Lots of work can be done on rats, and the problem was there weren't any human compounds. And the judge at 196 is saying, well, even with a human compound, human selective compound, there's still general clinical uncertainty. And you don't address that clinical uncertainty by putting the compound in a rat, because that doesn't tell you anything about humans, and it doesn't tell you anything about behaviour in a clinic in humans. So that's the point we're on at the moment. Sorry, my lady, I may not have answered your question, but it may
well, let's move on.
Let's move on. So if we then go on to, so I've dealt with 196, 197 and 198, we were just saying that the same point applies. Again, it's talking in the generality. It's not just about mirabegron. This is generally it wasn't thought that clinical trials would necessarily be fruitful. So it was possible that beta-3 agonists would work, and it's possible that they would not. So until someone is brave enough, makes a contribution to the art, goes into the clinic, we won't know the answer to that. And that's what the patentee hasn't done. As to oversimplification, the central problem facing the claimants seems to be the poor quality of disclosure of 288 as it applied to mirabegron in particular, and the examples generally. with the very limited data given. It was because of that that claimants had to contend effectively that any selective beta-3 AR agonist would be seen as obvious to use for the treatment of OAB. And again, this needs to be cautious, we're talking about human selective. My finding on the evidence as set out above are that that is not so, was not the perception of the skilled addressee. So we say the judge is, in his first of his 2 points, is drawing a distinction between the general appreciation that beta-3 agonists have potential to treat OAB on the one hand, and the uncertainty that this would translate into the clinic. We submit he wasn't allowed to attach weight to any of this in his analysis. And then at 200, just at the first sentence of 200, he says this does not mean the skilled addressee would positively think the mirabegron or the other examples in 288 would not work. It means that there is a substantial degree of uncertainty. So mirabegron falls into the same camp as all other beta-3 agonists in that respect. And I'd like at this point to go to have a look at some of the cross-examination to which he's referring to, his analysis of the evidence to which he's referring to. I wanted first of all just to pick...
Before we get into the cross-examination, can I ask you this question? Just says I'm not labouring up sort of misapprehension. Am I right in understanding that you accept, if we look at the patent, the data in the patent are sufficient to render the claim to efficacy plausible?
No.
If we don't accept that, why are we looking at 288 at all? Because the patent would be invalid.
No, but the plausibility comes from the general knowledge, the common general knowledge. So it's not the data. My Lord, I said the data makes it plausible. As a general matter, beta-3 selective agonists, that comes from 288, 111. The beta-3 selective
is to mirabegron.
Sorry?
The claim is to mirabegron.
Yes. So why is it plausible? It's plausible because it's a beta-3 selective agonist. How do you know it's a beta-3 selective agonist? Because that was in the art. So it is plausible. It's not plausible because of the data in the patent. Data in the patent doesn't make it more plausible. So we've not run a lack of plausibility case. We say it's plausible, obvious, and it's night follows day. Does that make our position clear?
Yes, thank you.
So I've just wanted to go to a couple of passages in the cross-examination, particularly those which the judge is going to rely on, but it just give a little bit of context. I first wanted to, and it won't take long, just first looking at Professor Mills.
Sorry, can I just ask you another question before we get into it? You go into the cross-examination having arrived at paragraph 200 in the judgment. But paragraph 200 in the judgment isn't about any of the evidence that was given, was it? It's about the interpretation of 288.
Yes, so really, sorry my lord, I'm really picking up the middle of one now.
Okay, all right, thank you.
My findings on the evidence are set out above.
Right, okay.
Sorry,
thank you.
I probably shouldn't have counted on to 200.
All right.
So if we look at first at Professor Mills, or Dr. Mills I think he was a clinician, but he was unusual in that he worked in a pharmaceutical company on drug development, and he'd actually done a lot of this bladder strip work himself during his PhD. So he's very much sort of very much a scientific clinician, if I can put it that way. Not that that matters, but if I could ask you to go to tab 8, I think is the day 3 cross-examination. And look at 326. And there were various squeezes running in this
What
case.
page number did you say?
326.
Behind tab 8.
Behind tab 8.
You mean internal page?
Yes, sorry, internal
Transcript
page of the.
Okay.
Sorry, I do apologise. The transcript page. Sorry, transcript page 326. And the witness is talking about what's plausible in the light of the priority document is the context how the questions start. And this is evidence he's given in his expert report. So I'm taking it 326 line 8. Given the proximal cause, a medicament with a direct action on detrusor to prevent involuntary irrepressible contractions, such as meribigron, would be expected to be effective to treat overactive bladder, regardless of the underlying cause. I put to him, you say there you would expect any beta-3 agonist to be effective to treat overactive bladder. Would you not, for the same reasons, expect mirabegron to be effective in treating overactive bladder? Because I mean, I would expect a drug that is able to relax the bladder, relax the detrusor, would be an effective treatment for overactive bladder, or could be an effective treatment for overactive bladder. Even before you read the priority document, you would have expected a beta-3 agonist to be effective to treat overactive bladder, would you not? Even before reading the priority document, that you would expect it to have potential to treat overactive bladder. Then we move on, and I show him another passage. The skilled clinician was aware that it was not possible to directly assess whether a candidate compound has an effect on urinary urgency until human trials stage of the drug. Researchers in 2002 therefore had to rely on proxy measures in order to infer candidates appropriate test for urinary urgency. As I understand it, what you were saying is that you will need to do a clinical trial, but based on the rudimentary data of testing beta-3 agonist on rat strips, you would expect it to be effective, have potential. Now this becomes important. So he's talking about rat, saying would it, yes, so evidence or the demonstration of the ability to relax detrusor muscle would make you believe that it could be effective, it would be consistent with that. Now the judge picks up this could at line 15, which is why I'm drawing your attention to that. So we say here that what the witness is doing is saying in this early passage is consistent with the claimant's case that a beta-3 human selective agonist is a potential therapy for OAB. And insofar as there is residual doubt, one needs to do clinical trials, and as you say, the patent doesn't deal with that. And he gives similar evidence in the context of Yamaguchi, so 252, this is the last passage we need to go to in this, line 5. If you impact beta-3, sorry, line 252, line 5, if you impact beta-3, the expectation is you're going to cause bladder relaxation, yes. If you are an agonist for beta-3, the expectation is you will affect bladder relaxation, at least in the sort of in vitro experiments that are being performed in this paper. On the
this paper being the...
Yamaguchi.
Yeah.
Sorry. From the data with the CL compound, I think you can make that conclusion that the beta-3 agonist effect of the CL compound is mediating its pharmacology, and that was the one where we looked at the graph. I think for isopropanol it would be too much to make that conclusion. Would the skilled team in November 2000 have been aware of any beta-3 agonists which did not cause bladder relaxation in the in vitro tests that have been described and discussed in the vitro bladder strips? I do not believe they would be aware of any that did not cause it, because I think the Yamaguchi article represents essentially what they would understand. That was Dr. Mills. I then want to go to Professor Murray, and that's in the next tab, day 4. And first wanted to deal with a specific point, which is which my lord put to me about the rat tissue. And remember, with rat tissue, you've got a couple of problems. First of all, in the rat bladder, there's beta-2 and beta-3. You've got that. And the second thing is you've got the fact that you bind to rat and you're selective in rat beta-3 doesn't mean you're going to be selective in human beta-3. And so this was put at 361, day 4. Murray was the pharmacologist, my learned friend's pharmacologist. If you test a compound on a rat tissue and it appears full and relatively strong in the rat, you cannot predict whether it is going to be full or strong in the human tissue. You have to test it. Sorry, no, what is it? So page 361.
Yeah.
Yeah. Whether it's going to be full or strong in the human tissue, you have to test it. That is absolutely correct, Dr. Turner. There's no dispute about this. And then if you go to 376, the same point arises. Line 13, you recall that the patent has extra examples. 376, it has an extra example 2 and an extra example 3. Do you recall that? Yes, that is the in vivo examples, the in vivo, yes. I appreciate you may be getting more confidence about its activity in a rat, but although these additional examples give you no additional information about how the compound will interact with the human receptor, it is giving you no information about whether in the human system will be partial or full or weak or strong. That is absolutely correct, Dr. Turner. I mean, it gives you comfort you've gone from a strip, of course, from a little bit of smooth muscle, you've gone to the whole system and it's doing something to the system. But you know, it's the crux of drug discovery. It's not human until you do something, even in a human system, when in fact you get into the clinic, you do not truly know what it's going to do. And again, my lords and my lady, I remind you, in the rat you've got beta 3 and beta 2, and you've got the fact that you're potent in the rat doesn't mean you're potent in humans and vice versa. And that is common ground. So then if we go to 374, line 18, this is a passage the judge relies on. We say he's wrong to do so, matter of law. So 374, line 18, I say, of course you always have to, biology is biology, you will have to test everything at some level, but if you have a beta 3 agonist, you expect it to have a measurable effect in rat detruser. I mean, we're not actually, in the end, that's not actually determinative of anything, but the answers given, I will be honest with you, in my experience, no. He was asked about rat detruser. So I'll be honest with you, in my experience, no. I was involved in a beta 3 agonist program with Pfizer in 2004, so we're now after the priority date. So it was after priority. I can shortly tell you, we have developed a number of compounds that in a cell line told us they were very good agonists. Whenever we got to the human detruser, they did not. So again, problem moving to human. There were other ones, looked okay and were brilliant in detruser. Not brilliant actually, they at least did something. So we found it very hard to produce a predictive spring sequence for this program. And then the judge reads on, I think we'll come to the judgment. Going back to 2002, obviously all this came later. Certainly the common general knowledge of the skilled person in Yamaguchi, because if you've got a beta 3 agonist, you would expect it to have an impact on the rat detruser. I think the common general knowledge would be the pharmacologist who worked in GPCR and understood agonism. You would say if you've got a good potent, good affinity compound, it's likely that you would see effect. Of course, that's all rat we're talking about at that stage. And then two last passages, I think. 391 on 25. Put a question at 391, line 25. I understand something is presented to you as a beta 3 agonist, and somebody says, look, I've tested it, and it's a beta 3 agonist. You would be interested because you do not have one. Let's assume you do not have one already, you're working on. You would want to recreate that beta 3 selectivity in your own hands. You want to test it in a rat detruser or human detruser muscle, would you not? Because that would certainly be the route you would take, yes. And you may do it with a number of different compounds if you actually looked in the literature and found a number of compounds in papers like the L compound in Yamaguchi. That has been suggested not just human selective, but actually having a bladder of laxing effect. You would prioritise based on the amount of data you had in front of you, which ones you could take. You cannot test everything. And finally, there was a bit of going around the houses on whether testing 6 compounds was excessive, and that's dealt with at 402 line 14, the last passage. it's not as competitor intelligence, but in a development program, synthesizing 23 compounds and testing them is not unreasonable. He says, no, absolutely not. In fact, we probably synthesized a lot more. That was the 23 we chose for that paper. I think we had been at cross purposes a little earlier, yes. And I think it was anything, in the end, it wasn't suggested that the 6 compounds in 288 would be an unreasonable number to make. Dr. Argentiatieri said it took a week to test 6 compounds. They have to synthesize. I wanted to pick up the cross-examination in the judgment. That's 101. So we'd had a look up to 100 before, and now picking it up. So this is the review of still in CGK, back in CGK at this point, I think. It was implicit in the claimant's position that the skill team would think that any beta-3 agonist would work to relax detrusor muscle, and therefore would be likely to work as a therapy for OAB. Again, it's just important, it's human selected beta-3 agonist would be of interest. I do not believe that that was the common general knowledge. Dr. McMurray disagreed with the claimant's position and said that it would be expected. Sorry, I beg your pardon, I just lost myself. I do not believe that was CGK. Dr. Murray disagreed with the claimant's position and said that it was expected that not all beta-3 agonists would behave the same, and I accept his evidence. He supported this with evidence, which I also accept, that Pfizer was found that some beta-3 agonists, which were potent in cell lines, did not work well in detrusor muscle. That predictability for agonists was always difficult and more complex than for antagonists. That work at Pfizer was not, of course, CGK, but it lends reality and support to Dr. McMurray's evidence on this point. So just pausing there, that's quite important. That's the passage we looked at 374. And obviously the judge recognises it's after the priority date. It also of note it's not evidence that was detailed in the expert reports, for what it's worth. Third, the details were not explored in cross-examination or re-examination because it was after the priority date and was not said to form part of the common general knowledge. So there's very little cross-examination on this. But there's nothing, you've seen the passage, there's nothing here in this cross-examination which is inconsistent with the Yamaguchi. There was a known problem of finding human selective beta-3 agonists. The witness, if you recall, had been asked about detrusor. Perhaps we should just turn it up again. The judge does rely on this passage. So if you just, sorry, my lords, risk of being burdensome, just turn it up again at 374, line 18, day 4. Tab 9. He gives the answer from 374. He's first asked about rat detrusor, but he answers different questions. So, to be honest with you, no. I was involved in a beta-3 agonist program with Pfizer, so it was after the priority date. But I'm sure you tell you, we developed a number of compounds that in the cell line told us they were very good agonists. And whenever we got to the human detrusor, they would not. So these are compounds, not saying that these were human selective beta-3 agonists. These are just compounds that they'd identified somehow, and then they didn't work well in humans. And again, that's precisely our point. So it's not a point against it. Say it sort of came out of the blue a little bit, and it's after the priority date, so its relevance is very unclear. Insofar as it matters, it's, you know, we say the judge was wrong to rely on it. The simple fact is after the priority date. and wasn't common general knowledge. But if he was right to rely on it, he was wrong to interpret it as suggesting that was of assistance to my learned friend. And then at 102, the judge continues, Yamaguchi identifies the need to identify better beta-3 AR agonists. What it says about them has an emphasis on selectivity, and refers to 507, but clearly also refers to the need for agonists to be full and potent. And then at 103, pick it up, it says L507 is mentioned in Yamaguchi, which itself was agreed to be common general knowledge. Said Dr. McMurray, then you just take it down to the end of the paragraph, there's a table. And he says only 3, so there are only 3 compounds which were shown to be promising beta-3 AR agonists for beta-3 AR, and one of them was 507. At 104, he says the claimants argued that no structure for 507 was available. Dr. McMurray said he thought it was. I was not told what source Dr. McMurray had in mind, but in view of his general care and reliability, I think he's more likely than not to have been correct. And then so the judge concludes at 106, so the overall picture is that there were many beta-3 agonists, but only 3, not only a handful, but in fact the judge has made it clear it's 3. Only 3 were human selective potent ones. 2 were not CGK, and there was limited information about 507. So the so then I think we can pick it up.
I'm not absolutely sure I understand where this is going.
So as we see, the point that is being floating around is how many. So we were arguing before the judge that the real problem in the art was beta-3 selective agonists, and part of that background is only one was known, at least in the common general knowledge.
Was only one what?
One was known. One human beta-3 selective agonist. That's the one referred to in Yamaguchi. That's 507.
507.
The judge says, the question is, do we know its structure? The judge says, well, there's no evidence on that, but I'm prepared to say its structure is probably known.
So how does that assist you?
So it assists us. So when somebody comes along, if you can imagine if there were 1 million beta-3 agonists out there, someone comes along and says, look, here's a human selective beta-3 agonist. I'm not going to be very interested in it. But in the context where there's only one in the common general knowledge, and you read a paper saying here are 6 human selective beta-3 agonists, we've gone out to look for human selective beta-3 agonists. Here are 6 examples. That affects, may not be determinative at all, but it affects your approach to that prior art. Does that make sense? Because what you want, what you need to take the art forward is human selective beta-3 agonists.
So you'd say that 288 supplies the missing piece of the puzzle, or at least gives you the key, because you can say, right, I'm waiting for this, I now can go off and test those 6.
Yes, exactly. I mean, in patent law, you have to read prior art with interest. Anyway, so let's assume that there are.
Well, that's true, but your argument is that the skilled reader here has a particular interest.
Exactly. My lords put it better than I have. Yes. Exactly. So Yamaguchi says, look, the real problem in this art, 2 things. One is getting hold of human selective beta-3 agonists. The other problem is no one's done clinical trials yet. And the 2 are related. No one's done clinical trials because of the shortage of human beta-3 agonists. And when they went off to do them in diabetes, they didn't have human selective beta-3 agonists. So when we go to 182, pick it up at perhaps 180. So we're now, sorry, that was going back to a little bit of common general knowledge, and I had to go back to that after I'd looked at the cross-examination. So that's why, because everything keeps referring back in the judgment. So we're now back to the cross-examination. So we're now just on obviousness. We're about to come, we're before the analysis we just looked at. But the judge, you will recall, at 199 said, my earlier findings. So we're now going back to the earlier findings. And at 180, says the claimant relied strongly on the following from Dr. Mills. You've seen that. And it says you would expect that it would have potential to treat overactive bladder. And we say that's a prima facie obviousness just there, and particularly when you're then presented with a human selective beta 3 agonist. And then you've looked at that cross-examination from Dr. McMurray, and the judge says these are to similar effect. Indeed, it might be said they're duplicative, and I thought at the time that both witnesses were careful about how they expressed themselves. They both made it clear it was possible there would be an effect, but there might not be. Dr. Mills did so by saying that there was potential. Dr. McMurray said an effect was likely for a good, potent, good affinity compound. So again, from what has gone before, we can see that the judge is considering the confidence with which one expects to see an effect in the clinic. And that, in our submission, is the evidence that he's referring to in paragraph 199. But I need to carry on with this passage. Says the context is also important. On the next page, from that quoted above, Dr. Mills said a compound could have a treatment effect, and that evidence of the kind was put to him was consistent with it. And then he refers to that his work in Pfizer after the priority date. So, and just to be clear, that the could, because the judge is suggesting the could is less than obviousness. So he's got potential, and then he's got a later could. But the could was assuming you've got a positive result in the rat bladder. He's saying that doesn't get. The judge is talking about those circumstances, not talking about a compound in isolation, insofar as that matters. Just that was at 375. So just bear in mind what the context of that comment. Then 184, he says, so he gave further reasons to explain why it is too simplistic to assume that any beta 3 agonist would work. So reasons why a compound might not work. The reasons being given are lack of clinical trials, and it may not be potent agonist at the human receptor. That's the key thing. So it may not be a potent agonist at the human receptor. That's what the witness is dealing with here. And what we don't know from the patent in suit is whether mirabegron is a potent agonist at the human receptor. The patent doesn't test it. Doesn't put it near a human tissue. Doesn't do anything. Has contributed nothing in that respect. And then we then get to a passage of cross-examination of Dr. Argentieri, which my learned friend particularly likes. We need to deal with that. So my learned friend puts to him this question: if you have a boss somewhere in the company, I presume you do, you went along to your boss and you said, look, I found a patent that tells me there are these 6 compounds which they think are beta 3 agonists. I do not know what their potency is. I do not know what their specificity is. They've been tried them for diabetes. They think they're good for diabetes. Do not give me the data. Nevertheless, I want to select these 6 over all the other beta 3 compounds that are in the literature. Just pausing there. In answer to my Lord's question, there's one other in the literature.
No, that's not
one
right.
CGK
It's not right.
Or 3.
One other found to be common general knowledge.
And then 2 others. That's quite right. It's 3 altogether.
But there were others in the literature. Yeah. In fact, they're not common general knowledge.
No, there were 3.
It's a separate point.
No, there are 3 in the literature. 3 human selective. Only 3. Can I just take you back to, because that's
well, I'm sorry, I seem to be have missed something here, because I quite understand what's common general knowledge, but I didn't understand the judge to have found there were none others known at all.
Yeah, well, this is yes, I think that is indeed the case. Let me just go to the find what the passage is, Stuart. What passage we're just looking at? Yes, so if you go back, my lord, to 102.
But this is all about what's common general knowledge.
We just bear with me a little bit. I think it's. So look at 103.
And look at 103, exactly. Dr. McMurray prepared a table of beta-3 agonist compounds, which he gleaned from the papers, in this case the prior art papers cited in the project. There were a large number.
However, only 3 were promising beta-3 agonists for the human beta-3. So there are lots of beta-3 agonists that work in the rat, but there are only 3 that were selected, beta-3, which were selected for the human beta-3. Only 3, this is from the table, only 3 shown to be promising beta-3 AR agonists for the human beta-3 AR.
Right.
So that's the one has to distinguish.
But it says only 3 were shown to be promising. So, for all one knows from this, there could be others where you just don't know one way or the other if they're going to be any good for human.
Well, they're not presented as human selected.
No.
Okay, so there are only 3 that were presented as in the papers in the case. At least.
Right.
We had a lot of papers in the case. So there are only 3 presented as human selected.
All
And
right.
only 1 in the commentary. My lord, it may not matter in the end, but I think my submission was correct.
Okay, thank you.
So,
But you were criticising the question. And the question is about all other beta-3 compounds in the literature. And your submission was it's a false question because there's only 3. Now, I can appreciate a slightly more refined submission that says it's an inaccurate question because there's only 3 that have been shown to be promising for human selectivity.
I fully accept that correction. Fully accept that. So the question that was put before me, and this is the witness, was given this patent, forget about everybody else's patents, forget everybody else's molecules, given the patent, would it be unreasonable to synthesize all 6 compounds and test them? And my answer that it is. No, so not unreasonable. So you were told to ignore any other compounds that have been discussed in the prior art. And the witness said, I was told to consider this a patent only. This is a source of some criticism and from the judge as well, but we don't quite understand why that would be. Of course, a witness is asked, of course the witness has to have the common general knowledge, but the witness is asked to consider the prior art in isolation. Otherwise, the witness is accused of mosaicing prior art. So, anyway, it's not a major point. And then we get an answer at 40A. Sorry, page 40. The next, so paragraph 1. We go over further in this answer, even if I call the kitchen sinklets. And the witness says, and here is an example of getting ahead of the competition right.
Sorry, where are you reading?
I'm still in the same passage.
Got it. Yes, thank you.
I think it's 144.
Yes, no, I've got it.
Sorry, my lady, I'm working on a different version. So my lady picks up, I've called the kitchen sink list.
Yes.
And then there's, and here is an example of getting ahead of the competition right. So if you want to wait till everything is laid out for you, all nice and tidy, that every other company with an interest in OEB is going to jump at it. And we say that nice and tidy, there's no need to over-interpret that. Nice and tidy would mean that if it had already been demonstrated that mirabegron works in the clinic, the witness is saying the idea would be to take mirabegron forward before it had been disclosed by others. That's what the witness is saying, no more than that there. But my learned friend likes, and so the skilled pharmacologist has to be a little bit crafty here and try and dig through assumptions and interpret statements. And then if we go on to the next question, what you are describing the skilled team does is rather akin to the punter at the racecourse who decides, I'm not going to go for the favourite. I'm not sure what the favourite would have been. I'm going to go for the second favourite. I'm going to go for one of the outsiders. I'm going to put my bet down on something which is no one else would consider to be a good prospect. Is that right? Not that other people did not consider it was a good prospect. So this is horribly abstract. But that you consider that it was a good prospect, and therefore it gives you a competitive advantage. That is very important. I'm smarter than everybody else. I'm going to take advantage of this. And of course, my learned friend likes this soundbite. And we have this betting analogy. I'm the comment by the witness, not that other people do not consider it a good prospect, but he's saying that it's smart to be ahead of the competition in taking drugs forward that have not been used in the clinic, not yet nice and tidy. So that's all we say that passage really goes to. It's not evidence of obviousness, at least not helpful evidence of obviousness. And then at 186, the learned judge says, Astellas pointed especially to what is said as a direction to Dr. Argentieri to ignore all other compounds. Claimant's response that it was not put to the witness had not given his evidence from the perspective of the ordinary skilled addressee. I disagree. And then dropping down, I also think he had in mind a narrow and incorrect question of what it was, divorced from the CGK, unreasonable to make compounds of 288. That is not to say that he was without technical grounds for his opinions, but his focus was not right. And of course, we say the witness's focus was right, but the learned judge's focus was wrong in these passages for the reasons we've been discussing, because the judge was concerned with, of course, prospects of success in the clinic following clinical trials. If I can then go back to where we were, so I'm now going back to 218. I think we got to 199, and so I was going to pick up. I think we looked at 200, and my lord pointed I probably got ahead of myself. So just going back to 200 as our judgment. We're now in the analysis of obviousness. And if you recall, the judge put forward two reasons. He said overstating the confidence and of oversimplifying the situation. We were on the first one. And then at 199, the judge turned to the oversimplification. We've just been looking at the start of that. He continues at 200. This does not mean that the skilled addressee would positively think that Mirabegra and all the other examples in 288 would not work. There's no prejudice, but it does mean that there's a substantial degree of uncertainty. We say that's uncertainty pending clinical trials, as the judge has made clear. Then looking at 201, the claimants try and bring some unity and reality to their arguments about B3-AR agonism on the one hand and 288 on the other, by the contention that the mechanism had been seen as extremely attractive for some time by the priority date was held up by a lack of appropriate compounds. Then it was said 288 would provide a good way forward for the first time. I have rejected this on the facts in dealing with the CGK. My lords and my lady, we looked at those. At least some other suitable compounds were around, and we've discussed that. And the skilled addressee would not think that there was a limitation, so that they would naturally decide to proceed with the ill-characterized compounds in 288. And again, we say this passage is infected with the judge's concern about how successful things will be in the clinic, the ACES tech point. But also we just remind the court that, of course, the lack of characterization of the compound of Mirabegron in 288 is precisely the same characterization in the patent in suit. All the patent in suit does is cross-refer to a patent equivalent to 288 and the same data. And then 202, it has some relevance that 288 does not mention OAB in the list of possible conditions to be treated. I do not think this is a critical point. I was then going to just drop down 4 lines. In the course of oral closing argument, in the context of this point, I asked counsel for Astellas whether he would accept that if 288 disclosed mirabegron as an excellent, potent and specific beta-3 agonist, it would then be obvious to try it for OAB, despite the conditions not being mentioned in the list. Initially, he accepted that it probably would be, although he caveated shortly after, and counsel for the claimants understandably sought to leverage this, so as to argue that all the claimants had to show was that 288 in fact did disclose mirabegron as a good compound in being selective. I did not think that counsel for Astellas was abandoning all its points, but the general uncertainty around beta-3 agonism and OAB, and in my view the shortcomings of 288, have to be seen and assessed on the whole. So the general uncertainty that is being dealt with at 202 is clearly still in the judge's mind. So this is the general uncertainty surrounding beta-3 agonism as an approach. And the concession made, or concession also made, almost made, is that if mirabegron was being put forward as a potent and specific error, it would be obvious to try it for OAB. And the argument against that is to say, well, okay, it was uncertain, but then the patent doesn't make it any more certain. And we're bang smack into the authority that we looked at, or the approach taken with the EPO and taken in ASUS Tech, that according to established case law of the Boards of Appeal, alleged advantages, which the patent merely refers without offering sufficient evidence to support the comparison with the closest prior art, cannot be taken into consideration. So, my lords and my lady, a submission that insofar as there was concern about lack of potency of mirabegron, that is not something that the court is entitled to take into account when assessing inventive step, because that potency is not disclosed in the patent in suit. I'm making progress, but that may be a convenient place to stop.
Yes, certainly. Very good. We'll resume at 10:30 tomorrow.
All right,